Welcome back. This is part 2 of the ESGR Ombudsman Mediation Process series. If you're joining us for the first time, start with part 1. It covers your role as a neutral mediator and how to handle your conversations with the service member. In this session, we're moving to the employer side. We'll cover how to approach that first call, handle the common pushback you'll encounter, and then walk through the resolution and closing process step by step. We'll also cover the timeline rules in detail, because that's where cases often get away from ombudsmen who aren't paying close attention. Let's get into it. Calling the employer is where most new ombudsmen feel the most uncertainty. It doesn't need to be complicated, but you do need to approach it right. Your opening statement follows the same pattern as your service member call. You're a volunteer with ESGR, an office of the Department of Defense, assigned to help resolve an issue with one of their employees. You're a neutral mediator. You don't represent the service member, and your job is to help clear up USERRA-related issues, not decide who's right. Your first task is finding the right person to talk to. Don't stop at the front desk. You need HR, legal, or a management decision maker. Once you're there, describe the issue, only what the service member authorized you to share, and then listen. Let them tell their side. Stay neutral throughout. You will run into resistance. That's normal. A few responses come up constantly. If the employer seems defensive, acknowledge that USERRA can look like it's stacked in favor of the service member. It often does. Explain that ESGR supports employers too. That's actually part of our mission. If they question whether you're legitimate, offer to get a signed consent form from the service member. That usually settles it. If they don't know USERRA at all, offer to send excerpts from the law and relevant FAQs and schedule a follow-up call. Don't try to cram a legal education into one phone call. Your goal isn't to win the conversation. It's to keep it going. Once you've talked to both parties, you enter what the process calls shuttle diplomacy. You go back and forth between the service member and the employer, sharing only what each has authorized, working toward common ground. It takes patience. Sometimes it takes several rounds. Sometimes it doesn't work at all. When you're closing a case, you'll use one of 5 closure codes in ICMS. Resolved means an agreement was reached. Not resolved means you made a good faith effort, and there's simply no agreement available. No contact SM and no contact ER apply when a party doesn't respond within 4 days. And other covers situations that weren't USERRA issues to begin with. If the case resolves, close it once the parties are communicating directly. Tell the service member to open a new case if the agreement falls apart later. Consider suggesting the service member nominate the employer for a Patriot Award. It's a good faith gesture and often helps solidify the relationship. Offer the employer a pointer to DOL Vets resources for the future. If it doesn't resolve, refer the service member to DOL Vets or recommend they consult an attorney. You've done your part. There's one more step after closing, and this one is non-negotiable. Delete everything. Every email, text, voicemail, and paper note related to the case. This isn't optional. It's required under ADRA confidentiality rules. The Alternative Dispute Resolution Act prohibits the retention or disclosure of mediation communications. Do it the same day you close the case. Let's talk timelines, because this is where cases get away from ombudsmen who aren't paying attention. Day 1 through 2, you make initial contact with the service member. That's your window. Not day 3, not when you get around to it. 2 business days. Day 4. If you haven't heard back from the service member by now, close the case as no contact with SM. Same rule applies to employers. 4 days of silence means close it. Day 7, the hard deadline for lost wages cases. These cases are time sensitive because someone's income is at stake. They get half the normal time. Day 14, the deadline for all standard non-wage cases. ICMS has to be updated after every single interaction. If you have a call, log it. If you send an email, log it. At a minimum, enter a note every 3 days while the case is open. This isn't bureaucratic overhead. It's your record of what happened, and it matters if a case ever gets reviewed. Sometimes 14 days isn't enough. Life happens. Maybe you're close to a resolution but need a bit more time. Contact your ombudsman director and request an extension through the national case manager in that situation. But be honest with yourself about whether an extension makes sense. Only request one when resolution is genuinely probable and imminent. If the decision maker is going to be unavailable for 2 weeks, don't extend. Close the case and have the service member open a new one when they're back. That's cleaner for everyone. Stay on the clock. That's part 2. You've now walked through the full 4-phase mediation process, from receiving the case to closing it out. Part 3 covers the principles that guide every case underneath the process. The golden rules, the decision framework for situations that don't fit neatly into the standard flow, and the full inventory of resources and support available to you as an ESGR Ombudsman. The final session is shorter, but it may be the most practically useful one. See you there.